On my presentation today, as the norm, will touch the vision, the mandate of the department, the constitutional mandate, objectives of the IES branch, functions of the IES branch. IES stands for Inspection Enforcement Services. And then we'll also touch on the Occupational Health and Safety Amendment Bill. And obviously, before I touch on the amendment bill, I must take you to the bit of a history of the legislation itself. And then we'll check on the OHS management system. This is quite important because this is now an addition in terms of Section 7 on the current Section 7 of the Occupational Health and Safety Act. So we've got a new part now, completely new on Section 7 of the new bill. And then we'll look at the status of compliance currently, and we look at the mega Blitz, should read Blitz, not bits, Blitz Inspection. And that will be the end of my story. The reason why we start with a vision of the department is because as time goes, you should understand that we are driven by that vision. We have to create a balance between amending the legislation and what is happening. So our vision is to strive for a labor market which is conducive to investment, economic growth, employment creation, decent work, without exclusion. What is important is that you may have noticed that the Department of Labor has changed from being just the Department of Labor, but it's now Department of Employment and Labor, meaning that employment is paramount. Employment is such a crucial issue in South Africa currently. So we must come up with policies that ensure that we preserve employment, or we create more employment. We preserve what we have and we create more employment. In other words, we shouldn't come up with policies that may be too hard on investors or on business or employers out there. So when we amend our policies, it means that we need to apply our mind. Again, our mandate is to regulate the labor market through policies and programs developed in consultation with our social partners. By now, you know our social partners: organized labor, organized business, as well as government. In organized business, I would say BUSA is playing a crucial role, Business Unity South Africa. And in terms of organized labor, we've got NACTU, FEDUSA, and COSATU as the federations that are participating in our advisory council in occupational health and safety, as well as the task teams. And this is aimed at improved economic growth, efficiency and productivity, creation of decent employment, and promoting labor standard and fundamental rights at work, and providing adequate social safety nets to protect vulnerable workers. The mandate, as I continue, of course, is to preserve sound labor relations, eliminating inequality and discrimination, enhancing occupational health and safety awareness and compliance at workplaces, giving value to social dialogue in formulation of sound and responsive legislations and policies. The constitutional mandate of our department comes from Section 24, which states that everyone has the right to an environment that is not harmful to their health or well-being. Now, as a branch, the Inspection and Enforcement Services, ours is to promote good labor practices, to provide information on all our labor laws, to ensure compliance with our labor laws. And again, our functions, we've got 5 functions: advocacy, followed by inspection, investigations, enforcement, and registration of entities. Now, you are going to get this presentation on the net. I'm rushing a little bit because there are areas where I'm going to dwell in and explain by and large. So this presentation you will get. So point number 1, advocacy, inspection, investigations, enforcement, and registration of entities. More often, people know us when we conduct inspections, but we conduct more advocacies than inspections. What I'm doing right now is advocacy sessions. And for those that did not know, if you've got a function like this, if you've got a function where you've got 30 to 50 people, you can call the Department of Labor. We'll come and conduct an advocacy session for free at your workplaces. as long as you've got the correct audience, because that's what we want to verify. So we are also operating on a zero budget, shoestring tight budget, but we will be able to meet your demands in terms of advocacy. So it is very, very important to mention that before we go into inspection and investigation and the enforcement part, normally we would have conducted the advocacy sessions. And that's why we are here today. And with me today, I'm with Ms. Huna. Ms. Huna is a senior specialist in health and hygiene. So she will be taking you through those regulations that falls under her section of health and hygiene, like your diving regulations, etc. Diving regulations was promulgated not so long ago. The amendments were promulgated not so long ago. Again, some of our functions include registrations of entities, as you know, divers, first aiders, explosives managers, magazines. Those are explosives magazines, you know, in explosives companies. That falls directly under my directorate. And then we register all electricians, government certificate of competency, MHI facilities, pressure equipment, some still call them boilers, lifts, escalators, passenger conveyors, etc. All of those have to be registered under the Department of Labor, Employment and Labor, and they fall under us. Now that I've done the formalities, let's come now to the crux of the matter, where things are really happening. Ladies and gentlemen, Aniali said you will recall that in 1918, now you can't recall, none of you were there in 1918. Only my grandmother was born in 1918. Sadly, she passed on in 2018, 100 years exactly. So may her soul rest in peace. In 1918, in South Africa, there was the Factories Act, which was promulgated at the time. In 1941, it was followed by the Factories, Machineries and Building Works Act. And then 40 years later, in 1983, we had what we call the Mosa Act. Now, I was starting to see things there in the Mosa Act time. You'll notice that some of the old lifts still have the plates written Mosa Act. It's still applicable. But what I want to emphasize, if you check from the Factories Act, Building Works Act to the Mosa Act, all of these acts were influenced by the economical activities of the time. So what was happening at the time influenced the legislation. So the more economic activities that are pulling to a certain direction, you will have a legislation that is pulling to that direction. So you will notice that South Africa, one thing that did put South Africa on the map in the 1600s was the discovery of gold. You know, the likes of Barberton, the PWV area coming to this side now, which is the northwest. All these areas, because of gold, when they were starting to boom, in the 1900s, Johannesburg, the factories now started coming in. Why? Because they have to supplement what is happening in the mining area. So hence we had the Factories Act at the time. But what you will notice is that immediately in 1941, Factories, Machineries and Building Works Act. What was happening in 1941? We're having a lot of booming, building. If you check on old photos of Johannesburg in particular, I'm saying it because I'm in Johannesburg, you will notice that around the 1930s, 1940s, in terms of development, buildings and so forth. And some of the things were bad because we're now having Group Areas Act. Some people were being moved to certain areas that they didn't want to. There were development happening all over. Then it necessitated at the time that you have Factories, Machinery, and then you have to add now Building Works Act. From the Factories Act, they added what? Machinery. Because machinery now, a lot of factories now are involving machinery. You are moving from manual labor. You know, the industrial revolution is taking place. You are moving from manual labor to more machinery. And then again, you've got a lot of buildings that are coming in. So 1941, we've got Factories, Machineries and Building Works Act. Come 40 years later, we've got the Mosa Act, Machinery Occupational Safety Act. Now, if you look at the Mosa Act, they've realized that now, other than factories and machinery and building, there's just a whole lot of occupation that are coming in that have to be governed. So the best word to use that covers everybody is occupational, because occupational simply means work-related. So everything now that is work-related, and that involves machine, its safety has to be taken into consideration. That is in 1983. Fast forward 10 years later, 1993. We've got occupational health and safety. Why occupational health and safety? The MOSA Act lacked one fundamental part. That was the health aspect. So we needed to add health. Now, occupational covers everyone. Now we've got occupational health and safety. You will notice that when you move to other countries who have been inspired, especially by the ILO, they say occupational safety and health. And mainly because for them, they have been dealing with issues of safety and health for a very long time. But in South Africa, issues of health were not dealt with, unfortunately, for a very, very long time. We are starting to take into consideration issues of health around 1993. And this is way too late. You will hear when Ms. Huna is talking to you today. This is way too late because now a lot of people have developed various diseases like asbestosis. And they acquired this asbestosis to factories that were adjacent to mine, which were using mining products from the mining environment. So these people, like for example, if you go to an area called Pomfret in Northwest, they've got heaps of asbestos that was left there. And factories were using that asbestos to create either asbestos roofing. And when I went to Pomfret, I was surprised. Even the tar road has been made from the ground that was mined from that asbestos area, meaning that it has got asbestos fibers. Even some houses there are still built from these asbestos bricks, because some of it was used to make bricks. These issues of health were not taken into consideration at the time. And the reason was that when an issue of safety, if it arises now, if I trip and fall now here, you immediately see that it's an issue of safety. But what you are not going to see immediately is an issue of health, because health takes time to show the result. So we've got a lot of health issues in South Africa in relation to respiratory diseases. And this was acquired mainly by companies that were using products from the mines. And not only that, in some of our areas, if you go to Emalahleni, Witbank, there's just a heavy fog of mist. And one wonders what will be the long-term effect of that area in terms of the environmental damage that is happening in that area. Now this, from 1993, it starts to say, you have to now take into consideration issues of health. That's why in South Africa, health comes before safety. That's very, very important. Health comes before safety. We have been taking care of safety. We've got reasonable knowledge of safety, not at the level that I would want it to be, but we've got reasonable knowledge of safety in South Africa. But when it comes to health, I think we are a little bit back. You will notice that employers don't invest much on issues like chairs. Hence, we have to come with ergonomics regulation, which I believe Ms. Huna is going to talk to that as well. Why? Because we have to invest on a proper chair if you are going to be sitting for long hours. And we have to, when I say invest on proper chairs, sometimes we buy chairs. I'm looking at the chairs that we're using now, right now. I would say by just looking at it, it carries an average weight of about 75 kilograms, isn't it? Or 80 kilograms. At a maximum, I'll put it at 80 kilograms myself, meaning that somebody like me shouldn't be sitting on it. Because even if you put 10 to 20% extra of 80, we should be another, 16, I think, 16. That will come to about 92 kilograms. I'm still above 20% of that. So meaning that might not be a correct chair for me for long term. Maybe for just an hour or so is fine, but for long term it might not be a correct chair for me. What happens when you sit to a chair that is not designed for you? Because it is not you who must suit the machinery. It is the machinery that must suit you. In terms of ergonomics. So if I was to sit on that particular chair long term, I'm going to start suffering from back aches and and paints there. It might not happen today. It can be long term. And that's what has been happening. And we can see a lot of claims that are coming through workmen's compensation of people suffering from back pains and the likes. Why? Because issues of health were not taken into consideration. We focus mainly on issues of safety because we can see that immediately. Now, the new bill, which was published on the 14th of April 2021 for public comment, the Occupational Health and Safety Amendment Bill number 422. I'm going to focus on it because here we are shifting now the mindset of the occupational health and safety in the country, whereby we are saying maybe the way we are legislating things now currently might be a little bit cumbersome. Imagine, for example, if you fail to comply with Section 17, which is to nominate health and safety representatives, and you are charged, you are found guilty in a court of law, it means you've got a criminal record. Then, yeah, currently as things stand, you've got a criminal record. I saw Advocate Reynard. Where are you? Yeah. Advocate Reynard is at the back. He will confirm with you that yes, you can be charged, and then you will be found guilty, and you will have a criminal record in your name for not having a health and safety representative. So those are some of the issues that we would want business, we would want organized labor, we would want yourselves as the community. Let us look into these issues. Do we really want issues of occupational health and safety to be criminalized? Yes, there will be other issues that will remain under the Criminal Procedure Act, but there are those things that are administrative in nature that shouldn't necessarily fall under the Criminal Procedure Act or be criminalized. Now, in terms of the amendment bill for the 422 of 14th April 2021, one of the additions is Health and Safety Management System, which states a coordinated, comprehensive set of interrelated or interacting elements to establish occupational health and safety policy and objectives in order to optimally manage health and safety. I'll send the presentation. Don't worry about memorizing for now. Concentrate on me. Risk assessment is said means the process. By the way, this definition wasn't there. This is a completely new definition, and the definition I read prior, this one, Health and Safety Management System, is a new definition altogether. This one, again, is a new definition. It says, risk assessment means the process of evaluating the risk to an employee, a person's health and safety from a workplace hazards, and is a systematic assessment of all aspects of work that considers a complete hazard identification, you know the HIRA process, hazard identification, risk assessment, identification of all who may be affected by the hazard. So we're no longer focusing on the employees only, everyone else who may be affected by the hazard of that particular workplace. That may include the public as well, agents or other people that are just coming in and out of your employment. How the person is affected, that has to be assessed as well. The analysis and evaluation of the risks and prioritization of the risks. Those who have done or who do a thorough risk assessment, you know that when we identify a hazard, we rate that hazard, we put in measures, it might be engineering measures or whatever measures that you can put in place, but you assess that risk, its impact after you have had any other health and safety measures, and you rate that and you do your risk rating, and you will classify it whether it's still critical or whether it's a bit lower or whether it's a bit mild, even before you put on your PPE and stuff like that. So you know that whole process. So basically that's what we are saying this definition is all about. Why this definition? This definition is as a result of you, ladies and gentlemen, who are going out to builders, warehouse, and okay, I'm advertising them, sorry, to all those warehouses, and then you go and buy a safety, it's called what? Safety file. I completely discourage that. You know, buying a safety file is not different from if you travel on the M3, because there's a lot of cameras there, and the other ones are sitting and waiting for you. You will notice that other fellow motorists, if there's somebody who's sitting on the other side with a tripod and a camera, what do, other fellow motorists? Isn't it? They flash for you. They don't love you. They shouldn't be flashing for you. But on the other way, I've realized since it makes people to slow down, so I flash throughout the whole way. Yeah, just to make you slow down. Yeah, I'm helping you. If I just think you're speeding, and I know you're going to slow down, and the moment you think, he's bluffing, that's when they catch you. So, but I say they don't like you. You know why? Because in South Africa, we are developing a culture of being evasive to health and safety standards and measures, not necessarily understanding what is the reason behind that health and safety measure. There is a reason why your car should not travel at more than 120 kilometers per hour. Because they've taken into consideration that there are taxis or minibuses in South Africa which are supposed to travel at 100. I don't know if they travel at 100. And there are trucks that are supposed to travel at 80, some of them. At the same time, road conditions, they matter. There may be other issues that you haven't taken into consideration. I bet you 90% of you this morning didn't walk around your car or do an inspection of your car. Or you did yesterday when you fill up the tank. Hopefully you did. But you see, all these measures, when they are taken into place, the decision is taken that the maximum you can drive is 120. Because it has been realized that 120, it's safer for you. Your reaction time also matters. How your car will immediately, your car probably is 2 tons, if it's like my car, 2.5 tons. Your normal sedan Corolla will be something like 1.5, 1.5 tons. Come to think about it, if you are pushing 1.5 ton at 120 k's and something emergency happens, what will be your reaction time, and how will you bring a 1,000 ton to a standstill? Chances are that you won't be able to, and then we end up having accidents. And that's why they arrive in South Africa. South Africa, we've got a challenge. Our challenge is that we do not learn of occupational health and safety at primary level. So in South Africa, we are dealing with a much bigger problem whereby people do not have the primary education when it comes to health and safety. And then you want to start by addressing ergonomics, issues of chairs and all that. They look at you as if you are mad. They look at you as if you are over-regulating industry and everything, simply because we don't have that primary education. So which is something that we need to work now with the Department of Education. We've already started. They form part of the advisory council now to say, how do we implement health and safety at a lower level? And in particular now, because we are dealing with COVID, everyone is starting to realize that it's not funny to have a mask on. Why? Because we are starting to see it happening. All right, coming back to the legislation. Section 7 of the amended bill. It says the chief inspector may direct an employer in writing or category of employers by notice in a gazette to develop and implement an occupational health and safety management system. Earlier on, I read to you the health and safety management system. So now the chief inspector may direct a category of employers to say, you will do a health and safety management system, and any category of employers by notice in the Gazette to prepare a written policy concerning the protection of health and safety of his employees at work, including a description of his organization and the arrangements for carrying out and reviewing the policy. Ladies and gentlemen, you will notice that this is still in bracket because some of these are not yet applicable. It's still an amended bill. We are still in consultation. But this is where we are heading. 2, any direction, a directive under sub 1 that I've read shall or may be accompanied by guidelines concerning the contents of the policy, occupational health and safety management system concerned. An employer shall prominently display a copy of the policy referred to in sub 1 signed by chief executive officer in the workplace where his employees normally report for service. Now, the last 4 parts that I was reading, 1, A, B, and 2, and 3 there, that is legalese. Ne? So don't worry about that. Me and you don't understand that. Okay, I do. Only Advocate Reynard understand. Now I'm going to bring it to a level that you understand it. Let me break it down to you. What is it that we are expecting employers to do? The employer should show commitment to OHS activities in the organization and make appropriate arrangements for the establishment of an OHS management system. Occupational health and safety policy. You will notice on the wheel, it's too small on me. Okay, you've got it there. You will notice that the wheel there has got policy, organizing, planning and implementation, evaluation, and action for improvement. So basically, what we are expecting in the new section is for the implementation of this. The employer, in consultation with workers and their representative, should set out in writing OHS policies which should be specific to the organization and appropriate to its size and the nature of its activities. The employer and senior management should allocate responsibility, accountability, and authority for the development, implementation, and performance of the OHS management system and the achievement of the relevant OHS objectives. System planning, development, and implementation. The purpose of planning should be to create an OHS management system that supports as the minimum compliance with national laws and regulations, the elements of the organization's OHS management system, and continual improvement in OHS performance. Evaluation, performance monitoring and measurement. Procedures to monitor, measure, and record OHS performance on a regular basis should be developed, established, and periodically reviewed. Action for improvement. Arrangements should be established and maintained for preventative and corrective action resulting from OHS management system, performance monitoring and measurement, OHS management system audits and management reviews. So when we are conducting our inspections, we would be expecting you to prove this to us. This is already in place, but now the new OHS bill, if you follow what I've just gone through there, you shouldn't go wrong. That covers now all the minimum requirements. This is already in place, but not to the extent at which now the bill will be expecting it from you. Now, as I started, I indicated this part. This I know some of you won't be happy, but as I indicated, those who flash the lights on you don't really like you, but you must do it so that people reduce speed like I do. 37A, inspector's powers. We are moving now to the normal way of just issuing notices, contravention notice, prohibition notice. Now we are moving into administrative fines. And I know somebody sitting and say, hey, this government wants to kill us. Not really. I'll explain. An inspector may make recommendations in writing to the specialist. We've got 2 specialist inspectors at the back, Mr. Warren Mullen. If you can raise your hand, Miss Elise Lawrence, they don't want me to point at them. They're at the back. They will be coming here. There should be 3. I'm not seeing the other one. She's supposed, yeah, but I've seen 2 specialists. Now, what will be happening is that inspector will make recommendation to specialist inspector that a fine be imposed on employer in terms of 7B if the employer contravenes or fails to comply with the provision of the Act. The inspector concerned must serve a copy of the recommendations on to the employer, the Health and Safety Committee, the representative of trade unions that you will read. The employer may make written representation to the specialist inspector within 30 days of the recommendation. So inspectors are not going to issue fines there and there. They will make recommendations to the specialist, like the lady and gentleman at the back. Ms. Huna is a senior specialist. So they'll be making recommendation to the specialist. Why the specialist? The specialists are responsible for writing the regulation. So just in case if an inspector has erred in the interpretation, the person who's responsible for that regulation or who chairs the committee of that regulation will be able to make the final assessment to say whether the fine should be imposed or not. So it's not automatic that when an inspector goes for inspection, the fine will stand. The inspector will make a recommendation of a fine which will go to a specialist. In head office currently, I'm working with 9 specialists and 3 senior specialists currently. In provinces, we've got 1 specialist each. So it's not more than that, because we are not expecting a big amount of fines that should be coming out from employers out there. All right, the employer may make written representation to the specialist within 30 days. So an employer as well can make representation to a specialist to say, but these are the mitigating circumstances that I want to put on record before that fine can be endorsed. Now 37B, these are all new sections, they are not on the current Act. 37B, the specialist inspector, after considering the recommendation and any representation made in accordance with section 37A, may disregard the recommendation. So they've got the power to say, the recommendation to impose a fine should not go on. Impose a fine not exceeding the amount mentioned in Schedule 2. I'll show you Schedule 2. Or refer the matter to the prosecuting authority for a decision as to whether the employee should be charged with an offense. So in other words, if we are not certain, obviously we will refer the matter to the NPA as to whether the employer should be charged or should be fined or not. Then 37D makes provision that any person aggrieved by the imposition of a fine as contemplated by section 37B may apply for a review to the labor court. So there is that process. It's not automatic like when you go, I'm going to be fined and so forth. It has taken a lot of thinking, because we don't want cold drink. You understand in South Africa when I say cold drink. You are looking very holy. Cameraman, you must swing the camera also to show their faces. When I say cold drink, they act all dumb like they don't know it. Oh, you like cold drink? Oh, people like cold drink. Okay, but on weekend we take cold drinks. This is the language that will be understood only in South Africa. The specialist inspector must notify the employer, the Health and Safety Committee, or if there is no Health and Safety Committee, to any Health and Safety representative responsible. I'll skip this because of time. An employer must pay any fine imposed in terms of section of this section within 30 days of the imposition of the fine. I would like to believe that we'll build something says or make arrangements. It's not yet there, but I would like to believe that we'll build something that way. If the employer fails to pay the fine within the specified period, the chief inspector may apply to the labor court for the fine to be made an order of the court. That means I'll have to make you now an order of the court. I wouldn't want to do that. Please just pay. Now, Schedule 2 of these fines, you will notice the contravention of Section 7. The section that I was talking about it with that wheel, you remember the wheel policy, although organizing and all that, you contravene that automatically. That's Section 7. If you have no previous conviction, that will be 50,000 rand. And then if you've got a previous conviction of the same matter, that will be 100,000 rand. A previous contravention within the previous 12 months or 2 previous contraventions, that will be like 200,000. And then there it goes, 3 contravention in respective of the same provision, 300,000. 4 will go to 500,000. And you can see that this is not good. This is not good, but we shouldn't even be reaching there. I'll explain to you why we should not even be reaching there. Now, having Schedule 2 and other sections that I have presented, you will notice that we dispute matters in labor court because these are administrative. It does not mean now we have done away with the criminal liability aspect. No, the criminal liability aspect is still there. In a case of where, let me read it for you, an employer, chief executive officer, manager, agent, user, or employer or employee commits an offense by contravening or failing to comply with the provision of this act, thereby causing the person's injury, death, permanent disablement, or illness. Now, if it falls under that, we'll still process the matter in terms of the Criminal Procedure Act, meaning that we may have inquiries and so forth and so forth. I just need this 15 minutes to finish. I can see my wife saying 15. An employer, chief executive officer, manager, agent, or employee commits an offense by performing or omitting to perform an act of if the act or omission falls within the scope of the authority or employment of the employer concerned. So that as well falls under criminal liability. Everything that I was talking about, from the fines that are being imposed, the criminal liability aspect, everything has to be tested in terms of the decision of that. Now, is it an abbreviation? No, it's not an abbreviation. I wanted to define that term, the definition. That's what I'm looking for. Now, every decision has to be taken in terms of that definition of reasonable, practicable, meaning that a specialist or a chief inspector or a senior specialist, before they can take any decision, they must take into consideration the severity of the scope of hazard or risk that is concerned, the state of knowledge reasonably available. We cannot charge you for something that we don't have knowledge of. Are we clear on that one? So it might be something that is clear that there is knowledge reasonably available concerning that hazard or risk, and we know how to remove, mitigate that hazard, which you did not do. So we are able to prove beyond any reasonable doubt that you could have removed or you could have mitigated this. The availability and suitable means to remove or mitigate that hazard. Did you have the means to remove? So those are some of the questions that we need to ask ourselves. The cost of removing or mitigating that hazard. So it's not going to be a one-size-fits-all approach. It goes also in accordance to your business. I mean, we cannot find a business 50,000 rand that is not making 50,000 rand per annum, because there are small businesses of 2 people that are barely surviving, especially in these economic times. People are just fixing geysers. It's just two individuals who are making geyser replacements and so forth. We need to apply our mind. That's why we need to apply that term reasonably practicable. So it's not a matter of just saying, your hands, no inspector will be issuing fines. They just make recommendations to specialists who must now apply their mind in imposing those fines. So it's not something that is going to be rife. I'll show you in statistics, if we were to issue fines today, how many employers would have been issued with fines. I'll show you that on the statistics. Now, I want to show you that through the mega blitz inspections that we have done. We've been doing Mega Blitz Inspection. This is an initiative of the Minister of the Department of Employment and Labor, together with the Inspector General and myself. So we have been going to provinces, conducting inspections even before my previous predecessor left. We've been going to provinces making these inspections. Our objective really is to increase awareness, heighten our visibility, and improve compliance level. Now, so far we have gone to about 5 provinces. Again, improvement in the level of partnerships with various key stakeholders, improved interactions with vulnerable workers. We interview workers as well during the mega Blitz inspections to explore areas of cooperation amongst the different stakeholders as well. So we are not just doing inspection, but we are looking at various spectrums in terms of the 5 areas of functions of the branches activities that I mentioned earlier on. So we have already done 5 provinces that I can give you now. Last week I'm from Harrismith. We're doing Free State, but I spent my time about 4 days in Harrismith as the town, trying to evaluate what is happening. I don't have the statistics of Harrismith as yet, but I was quite impressed. I went into this company, I've forgotten the name, but they manufacture carpets. It's rare for me to get an employer that complies to that level. Well, they are selling their products internationally. They employ about 100 people. But I was quite impressed by their level of health and safety standard. If you do get 80% from me, you must be very, very good. Nobody gets 80% from me in my last 25 years. If you are good, you get about 70. There will still be other things. There are other things that I wanted them to improve on because I could deduce that there were near misses. That's why they never had any incident. But all in all, they were complying with most of the things. But about 200 meters from that company, there's a guy that we had to completely close down. I mean, this guy is a miracle worker. I mean, he connects, a normal extension cord that you use at home. I don't know how he does it, but he can connect fluorescent light at a parallel formation in his factory with one cord. And no COC, nothing. I don't know how he does it. I should have brought the pictures. These are the provinces that we went to. As you can see there, you've got Eastern Cape, Western Cape, KZN, Limpopo, and Mpumalanga. Now, this is their compliance level. The non-compliance is in that reddish color, if I may call it that. Burgundy red, yeah, let's call it red. The other one is green and the other one is blue. The blue is the total inspection, the red is non-compliance, and then the green is compliant. Can you see that only in Limpopo the green was a little bit above the red? But if you look at other provinces, I mean, Mpumalanga was the worst. I mean, I've never seen the level of non-compliance like what I've seen in Mpumalanga. I mean, I went to this area, it's called KwaMhlushwa. I mean, these guys have got a 40,000 liter of diesel, it's petrol, and paraffin. Literally, not a joke, not exaggerating, literally just 20 meters from the main road. Yep. From the main road, KwaMhlushwa, you can see it, it's there. And now it was a catch-22 situation. I can't prohibit him because the tanks were full to capacity at the time. So I just had to stop now the supply so that they can drain the whole thing empty. Needless to say, it's an inquiry on that matter. But I've seen it happening. Why at KwaMhlushwa? Because they have targeted those rural areas. They can do as they please. You go and put all your big tanks there. Nothing, no container. If there was to be a spillage, nothing. No safety measure at all. But there's a lot surprising about that story because, by the way, this is about a month and a half ago. But the liter of diesel there was about 17 rand. So how he got it at 17, I don't know. So there's a lot being said, are we having cross-border fuel and so forth. So that's why it's an inquiry on its own. But those are some of the non-compliance that we are seeing now. And if you can see in KZN, we're at about 2,818 of those inspections. All in total, is 4,783 that we did in the last, I will say, 6 months. Going to these places. And what is interesting, we are using a roving team. We are not using the local inspectors. We are avoiding cold drink. We are trying to check the level of local inspectors and roving team and national team when it comes as to what are the levels. And after that, we'll conduct an inquiry now in the department as to why when we go to that employer is not complying, but when the local inspectors are going, the employer is complying, being the same one. So we are coming to that level as well. So hence, this project now falls under the Minister, the Inspector General, and myself. And that's why I'm saying I spent about 4 days in Harrismith going. I did go to an employer who was deemed to be complying by the local office, but when I went there, the employer was not complying with the local inspector now. So this is very interesting. So we are doing all checks and balances, both internally and externally. The level of non-compliance, again, as you can see, Mpumalanga was sitting at 13%, sorry, Ms. Huna. Limpopo is 58%. I was saying compliance level was just at 13, and Limpopo was 58. Limpopo has dropped. We did a follow-up not so long. The results are not yet there. Limpopo has dropped. It's now at around 46% compliance, no longer at 58, because now we have included even the farming community that were not covered previously. And now, if we were issuing fines, let's say the bill was in place now, we were using it, I'll definitely be sure that we would have issued at least 19 fines of the 4,000. That's where we've issued prohibition notice. We would have issued at least a minimum of 50,000 each of these 19, of the 4,000, this 19 we would have issued. The improvement notice, no fines imposed there. These are merely recommendations. And then contravention notices. This is where, even though you've contravened, we give you 60 days to comply still before we can even impose a fine. So we still even give you time to rectify. But where we realize that, look, this is dangerous, it will be straight prohibition, and we'll have to impose that fine that I've talked about. But we've got 976 of those that, of the 4,000, we've got about 976. Sorry, of those that, I'm getting blocked now. Sorry. 976 of those that contravened our regulations. So I've included the compliance orders from the basic conditions and UIF and COID. Why did I do that? So that you can compare compliance rate in occupational health and safety and other legislation. Guess what? You will notice that the green part, which is contraventions, is still taking 51% of non-compliance, meaning that occupational health and safety is high in terms of non-compliance, even if you were to compare it against your basic conditions or your UIF or your COITA. Meaning that we still have a mountain of work to do, because all those there, that purple ones, these are other legislation combined. Occupational health and safety is the green part only that you're seeing there. And the improvement and prohibitions, those are occupational health and safety. So you can see that the level of non-compliance, you see in the non-compliance category, occupational health and safety is still very, very high. Ladies and gentlemen, if we've got 51% of non-compliance, it means that we've got a potential of causing an injury or death on those 900 companies of the 4,700 we inspected. This is not important. You will get it on the presentation. I forwarded the presentation to Mr. Norkia yesterday. I will forward it to the organizers, and then they can forward it to you. They've told me that they will put it on the website or YouTube. Yes, you can always get the presentation. This is for public consumption. It belongs to you. Ladies and gentlemen, thank you very much. I don't know if you have organized that I should take questions, but the time was very minimal. So I'm happy.
Thank you so much.